Hello everyone. In this presentation, which is the last one in this series, we will focus on quasi-contracts. What are quasi-contracts? Contracts are agreements enforceable by law and they are created by the parties. The rights and obligations are imposed by the parties themselves, whereas in certain cases, the law imposes an obligation and allows action to be brought on it as if the obligation arose out of an agreement between the parties when in fact it is not. These are called quasi-contracts because here there is no contract between the parties, but the law puts them in the same position as if there was a contract between them. The principle on which quasi-contracts are founded is that no person should be allowed to unjustly enrich himself at the cost of another. The law of quasi-contracts is therefore called the law of restitution. Section 68 to 72 of the Contract Act deals with 5 types of quasi-contractual obligations. According to Section 68, where a person incapable of entering into a contract is supplied with necessary goods and services according to his condition in life, the person supplying the necessaries is entitled to be reimbursed from the property of the incapable person. For example, the minor and persons of unsound mind are liable to pay for the necessaries supplied to them and their dependents. According to Section 69, where a person who is interested in payment of money which another is bound by law to pay and therefore pays it, he is entitled to be reimbursed by that other person. For example, A rents his house to B. A, as an owner of the house, is required to pay property tax every year. Where B, the tenant, pays it, A has to reimburse the amount to B. According to Section 70, when a person lawfully does anything for another or delivers anything to him without an intention to do it free of cost, and the other person enjoys the benefit from the act or thing, he is bound to compensate the person doing or delivering a thing, or restore the thing delivered. For example, A fruit vendor, leaves fruits at B's house by mistake. B treats the fruits as his own and consumes them. He is bound to pay for them to A. According to Section 71, when a person finds the goods of another and takes them into custody, he has to take care of the goods and take all steps necessary to trace the owner. He can keep the goods till he finds the owner. Where the goods are perishable or the owner could not be traced despite best effort, or when the owner is found but refuses to pay lawful charges to the finder and the charges incurred in taking care of the goods is 2/3 the value of the goods found, the finder can sell the goods. Under Section 72, when money is paid or anything is delivered by mistake or under coercion, he has to return it to the person who paid or gave it under mistake or coercion. Here, coercion is used in the general sense and not as defined under Section 15 of the Contract Act. And there is no distinction between mistake of law and mistake of fact for the purpose of this provision. Quantum merit. What is it? It is a claim on quasi-contractual obligation which is implied by law under certain circumstances. Quantum merit means as much as earned. When a person does some work under a contract and the other party repudiates the contract or the further performance of the contract becomes impossible, the party who performed the work has to be compensated. Circumstances under which a claim can be made are when an agreement is discovered to be void, or when something is done without an intention to do it free of cost, or when there is an express or implied contract to render service without an agreement for remuneration, or when one party refuses to perform the contract. When the obligation created by a quasi-contract is not discharged, the injured party has to receive compensation from the party in default as if there was a contract between them and it was breached. Where the contract is partly performed and the party not in default has enjoyed the benefit of part performance, the party in default may sue for quantum merit. For example, A builder, agrees to build a 2-floor building on B's plot. A completes 1 floor and defaults. B has to pay the cost of building 1 floor to A, or else A can sue for quantum merit, that is, for the part performed. When the contract is not divisible, that is, it requires complete performance as a condition for payment, party in default cannot claim remuneration on the ground of quantum merit. Where an indivisible contract for lump sum is performed in full but badly, the person who performed the contract can claim lump sum, but the other party can deduct money for bad work. This in brief is about quasi-contracts. In the 11 presentations in this series, an attempt has been made to explain the general principles of contract as contained in the Indian Contract Act. Thank you.